global happenings today. We communicate, we analyze global news.
Hello beautiful people, welcome back to our channel. Finally, the matter in court has been addressed. Some few minutes ago, Nnamdi Kanu arrived in court, but something uniquely different took place today in court. Nnamdi Kanu was not brought in early. DSS deliberately delayed him simply because they wanted the officiating judge to be on ground before they arrived, so that there will not be photoshops, videos, and him greeting people, because it's assumed allegedly that the president of the United States of America may be interested in what is going on in Nigeria, particularly Nnamdi Kanu's case. Is alleged anyway. But let's hear what those who were in court, of course were not allowed to speak in courtroom because we all understand that, said on what transpired in court that is definitely making rounds on social media. Let's listen to them back for more.
The law that I have contravened, yes. You cannot ask me to enter a defense for a law that does not exist, and particularly the law that the Supreme Court itself has declared non-existent. So what will I be defending? We're in a country where our laws are written. This is not England, where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. They made the law we're talking about. And if you ask him, he will tell you that there is nowhere they missed chapter 45 of the criminal code. They didn't make it. But honorable, people make that law. It is not in existence. So who made that law? Who made that law? Was that law made by the Attorney General's office? And the Attorney General does not have the powers to make laws. So I am saying, as an ordinary citizen, that Nnamdi Kanu is completely right and within section 36 of the Constitution, which borders on his fundamental right to fair hearing, to be charged in a court with a law that is in existence, not with a law that is not existent. Thank you. Thank you.
14th October this year, made it 10 years that this case has been pending. That the matter has become too complicated for the judiciary to handle underscores our core point, that this matter is more political than legal. That this is a matter for the executive branch to settle with a political sleight of hand. It's not a matter to be offered to the limited wiggle room of a court of law, of the judiciary. There is a lot of wide bat, a lot of wide space left for politicians or political leaders of this country to resolve political issues that border on agitation. Why this one has become intractable is very, very, very disappointing. There's a thesis that has become intractable because Nnamdi Kanu is an Igbo man. That thesis is becoming more and more valid by the day. So what is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
Is this a call for political intervention of this case?
Well, of course, everybody is calling for that. It's not throwing in the towel. What is wrong with calling with reconciliation when the courts of the land actually recognize it as well? Check out Section 17 of Federal High Court Act. It called on judges to seek reconciliation between litigants before them, including criminal cases. Section 174 of the Constitution empower the Attorney General of the Federation to discontinue criminal prosecutions. So why should anybody say this matter should be resolved in courts when we have an alternative route of resolving it politically that appears to be easier and that would appear to be pleasing to everybody?
Okay, let's talk about
the procedure today.
the proceedings today.
Okay.
What next?
I will yield to one of my colleagues to discuss that by Sama Square of
Okay, actually, it's good for us to put the record straight.
Nnamdi Kanu is not saying that he will not enter defense. Nnamdi Kanu said, under what law are you charging him? Going by the constitution, there is no absolute no charge against him. That tell me the law. That the court should tell me the law upon which he's being tried. Now, my lord is on so saying that whatever thing that you have to say should be good at the final written address, and it should be upon a conviction to know whether you're supposed to be convicted. I'm not going to say no. There are thresholds, there are hurdles upon which you need to cross for you to reach that particular issue. And one fundamental issue there is that my lord said, we are talking about issue of extraordinary rendition, the way you have been brought back from Kenya to Nigeria. And he wants somebody to come and give evidence on that. There is nothing before him. And if you watch the motion Nnamdi Kanu filed, Nnamdi Kanu said, Federal High Court has given a judgment in respect of that, and also awarded 500 million against federal government in his favor. That judgment is in the court file. Court of Appeal, in their judgment, also gave ruling on that and made comment about that. CTC of that judgment is in the court file. Supreme Court, in their judgment, also took judicial notice of that and they condemned that attitude. They are all in court file. There was a motion challenging the decision of the court where these issues are being raised, and Nnamdi Kanu made reference of the motion in the court file. Yes. And under the Evidence Act, Nnamdi Kanu is saying that under the law, court is obliged, is under obligation to take judicial notice of every document in your file. Yes. So asking him now to go and enter into a defense and start giving evidence on that is a waste of time. Yes. That court is on its own supposed to take so much to raise this issue. Yeah. Court is expected to raise this issue. Now there is a charge before me. Please, under what law? Address me on this issue before I go into trial. And Nnamdi Kanu filed a motion, and I think that motion, Nnamdi Kanu said that motion should be heard, and all this issue I raised should be tracked for me to go into trial. So I'm into defense. So my lord, Nnamdi Kanu maintain his position on that. So my lord said that he has gone to tomorrow for him to get that defense. Just like we said, you know, we are no longer into the matter, but we are still consulting us. I am saying so on handling his matter in court. He felt that he's competent to do that. So whatever advice he needs from us as his lawyer, we should also offer the legal advice, just to get the record straight, so that people will not say that Nnamdi Kanu refuses to enter defense. No, there is no such issue. Nnamdi Kanu said, address me on this issue. Okay, that's
the honorable member here would like to say.
Representing Nnamdi Kanu.
Well, my name is Right Honorable Obi Akocha. I represent the great people of Ikuano, Umuahia North and Umuahia South for the constituency of Abia State. I represent Mazi Nnamdi Kanu. From what I saw today in court, there seems to be a systemic effort being put in place to steamroll and railroad Mazi Nnamdi Kanu into putting up a defense and leading to conviction. There are procedural issues that must be heard before the matter can go forward. And I think that is the motion that must be heard, hopefully by tomorrow. Nnamdi Kanu still remains a prisoner of conscience. He's been detained unlawfully. And we are also using this medium to continually call on Mr. President to invoke Section 174 of the Constitution of the Federal Republic of Nigeria as amended, for the Attorney General to enter a nullity rescue, at least before the determination of the court. We are very optimistic that Mr. President, that we know is a listening and attentive president, and that he will do the right thing in the shortest possible time.